Students are joining. We will start in a minute. Hello, good morning, and welcome to Byju's Exam Prep. In the last class, we discussed Article 370 and had to discuss 35 capital A. Now, let me briefly recap what did we discuss on Saturday. Jammu and Kashmir, a princely state which integrated, acceded to the Union of India under unique circumstances because of the war, and later on because there were some United Nations Security Council resolutions. And for that, temporary Article 370 was introduced in the Constitution. Very briefly, what is Article 370? Number one, Article 238, which talks about various states. What should be the relationship with those states? That article does not apply to Jammu and Kashmir. Only Article 1 and Article 370 apply to Jammu and Kashmir. Union list, state list, concurrent list. The state legislature will have the power to make laws on all these subjects, not just state and concurrent list, all the subjects mentioned in the union list as well, except defense, external affairs, and communication. But can other items in the union list also be made applicable? That means, can Parliament tomorrow make law on any other item mentioned in the union list other than defense, external affairs, communication? Yes, but that requires concurrence of the state government. Similarly, when only Article 1 and Article 370 of the Indian Constitution is applicable to Jammu and Kashmir, can any other article other than 1 and 370 be made applicable to Jammu and Kashmir? Yes. For that, what is required? Concurrence of the state government. But these provisions of Indian Constitution can be made applicable to Jammu and Kashmir with such exceptions and modifications as the President may by order specify. President will specify in this order that this part of Indian Constitution, this article of Indian Constitution will apply to Jammu and Kashmir with the concurrence of the state government, but with these exceptions, with these modifications. Further, no amendment to Indian Constitution will automatically apply to the state of Jammu and Kashmir without the concurrence of the state government. But what about Article 370 itself? It has a self-destruct clause, which means it can be deleted, it can be abrogated, it can be modified. How? By the President, by issuing an order, but this time with the concurrence of Constituent Assembly. Of Jammu and Kashmir. Clear? This was what was mentioned in the original constitution in 1950. But on the other hand, in 1951, the Constituent Assembly of Jammu and Kashmir was set up. It took a lot of time, and in 1956, the Constitution of Jammu and Kashmir was adopted, enacted. But parallelly, there were also talks going on between Sheikh Abdullah, who was the Prime Minister of Jammu and Kashmir, and the government of India. These talks were basically of integration. How can we integrate Jammu and Kashmir more with the Union of India? Because right now we have limited powers on Jammu and Kashmir. We have limited jurisdiction on Jammu and Kashmir. How can we integrate Jammu and Kashmir into Union of India? For that, there were talks, and these talks resulted in Presidential Order of 1954. Even before that, Sheikh Abdullah was arrested. Why was he arrested? That case is known as the Kashmir conspiracy case. It was alleged that Sheikh Abdullah is now willing to even seek independence or maybe accession with Pakistan. So he's not entirely committed to a complete integration with the Union of India. He was arrested and spent close to 22 years in jail. But be that as it may, once Sheikh Abdullah was gone, his close confidant, Bakshi Ghulam Muhammad, became the prime minister. And now Bakshi Ghulam Muhammad and the government of India, they are in talks with each other, and these talks resulted in Presidential Order of 1954. And what is this Presidential Order of 1954? Listen to me carefully. Only Article 1 and Article 370 applies to Jammu and Kashmir, right? Yes. Can other provisions of Indian Constitution, can other subjects mentioned in the Union list also be made applicable to Jammu and Kashmir? Yes. For that, what is required? President will issue an order with the concurrence of the state government. Now, the state government is headed by Bakshi, and it led to this presidential order. And this presidential order was celebrated. And this presidential order was modified multiple times. Modified multiple times in a sense. This was issued in 1954, but over a period of time in 1960s, 70s, 80s, even 90s, this order was amended, modified, so that other provisions of Indian Constitution will also be made applicable to the state of Jammu and Kashmir. And it is celebrated because it was because of this order that Supreme Court got applicable to Jammu and Kashmir. Because of this order, UPSC got extended to Jammu and Kashmir. Because of this order, Finance Commission got applicable. Because of this order, emergency provisions of Indian Constitution got applicable to Jammu and Kashmir. President's rule got applicable to the state of Jammu and Kashmir. Jammu and Kashmir had its prime minister and the Sadr Riyasat, also known as the president. These nomenclatures, this name was changed. Sadr Riyasat became the governor. Wazir-e-Azam or prime minister became the chief minister. So this presidential order was celebrated throughout India. Why? Because it was through this presidential order that president applied other provisions of Indian Constitution, other items mentioned in the union list to the state of Jammu and Kashmir, but with the concurrence of the state government. But what nobody noticed, or very few noticed, was it was because of this presidential order of 1954 that Article 35 capital A got added to Indian Constitution. And what is this 35 capital A? This article of the Constitution, which is only applicable to Jammu and Kashmir, it empowered the state of Jammu and Kashmir that what you can do, you can identify. What can you identify? The permanent residents of Jammu and Kashmir. Who are these permanent residents of Jammu and Kashmir? Also known as state subjects. And then what you can do with these permanent residents of Jammu and Kashmir? Only them can get government jobs, can buy land, can acquire property, can get government scholarships. When the talks were going on between Bakshi and the government of India, ultimately these talks were on how can we extend Indian constitution to Jammu and Kashmir? How can we add more and more union subjects, union list subjects for the state of Jammu and Kashmir? But for that, Bakshi said, I need some protection. What is the protection? We will apply most of the provisions of Indian constitution to the state of Jammu and Kashmir, but we need to protect our state subject law. And what is that state subject law? In 1920s, when Maharaja Hari Singh was the ruler of Jammu and Kashmir, he was petitioned by the people from Jammu, he was petitioned by the people, the Kashmiri Pandits, that Maharaja, please do one thing. There are wealthy people coming from Punjab. There are wealthy people coming from India, because at that time J&K was the princely state. And these wealthy people, they will settle in Jammu and Kashmir, they will snatch our jobs, they will snatch our property, they will buy our land because our land is cheap, they have the money. So over a period of time, we will lose our influence in the state. Maharaja Hari Singh said, don't worry, I will introduce a state subject law. And through this law, only those who are the residents of Jammu and Kashmir, they can buy land, they can buy property, they can get government jobs. And now Bakshi wants that this protection, this state subject law should continue even after the presidential order of 1954. The government said, okay, don't worry, we will do it. But Bakshi said, how can you do this? Because this would violate your fundamental rights chapter. Because I've read your constitution. Your constitution talks about fundamental rights, and these fundamental rights say right to equality, right to freedom of movement, right to reside and settle anywhere within the territory of India, right to property as a fundamental right. So how can you say that now, since fundamental rights chapter would also be applicable to us, but how can citizens of India who are not the residents of Jammu and Kashmir, how can they not buy land, property, get jobs in Jammu and Kashmir? That would be violative of fundamental rights chapter. Government said, don't worry, you need to look at Article 370 again. Other provisions of Indian Constitution shall apply to the state of Jammu and Kashmir, but with such exceptions and modifications as the President may by order specify. And President, in this presidential order of 1954, specified that there is an exception. Exception is Article 35 capital A. Fundamental rights chapter will be applicable to Jammu and Kashmir, but with this exception of 35 capital A, which is only applicable to Jammu and Kashmir, where only your residents, your citizens, that is why J&K used to have dual citizenship, citizen of Jammu and Kashmir, citizen of Jammu and Kashmir as well, citizen of India and citizen of J&K. And that is how, through this modification, 35 capital A, only the residents of Jammu and Kashmir, or should we say the citizens of Jammu and Kashmir, or state subjects of Jammu and Kashmir, can buy land, property, can get government jobs, and can get scholarships of the government. But nobody paid much attention to this article because various other provisions of Indian Constitution, which were initially not applicable to Jammu and Kashmir, now got applicable. That is why various members in the Constituent Assembly, they said, don't worry about Article 370, because Dr. Ambedkar was against this. Dr. Ambedkar was against the idea of giving this some sort of special status to Jammu and Kashmir. But other members of the Constituent Assembly, particularly of the government, they said, don't worry about it, because it is the tunnel through which Indian Constitution applies to Jammu and Kashmir. If there was no Article 370, then other provisions of Indian Constitution could not be made applicable. Other provisions of Union List could not be made applicable. So it is through this tunnel that Constitution of India flows into Jammu and Kashmir. But nobody paid much attention to Article 35 capital A, but then over a period of time, it was challenged in the court. and at least in 2 judgments, the Supreme Court has upheld the validity of Article 35 capital A. But just before 2019, there was a petition in the Supreme Court challenging 35A. And what was the challenge? What was the ground of the challenge? Number one, how can the President of India amend the Constitution on its own? Because who has the power to amend the Constitution? Parliament under Article 368. But Article 368 was not used. Parliament did not pass a constitutional amendment bill to add Article 35A to the Indian Constitution. 35A is part of Indian Constitution. If it is part of Indian Constitution, it should have been added to the Constitution by the Parliament by passing a bill under Article 368. But this 35 capital A is introduced into the Constitution by the presidential order. How is that possible? That was the challenge. And if it is possible, but then how can you deprive the citizens of India their fundamental rights by not allowing them to buy land, property, get government jobs and scholarships in Jammu and Kashmir? That was the challenge before the Supreme Court. And even before that, in State Bank of India case, one judge, Justice Rohinton Fali Nariman, gave a judgment wherein he said Article 370 is permanent. It is now a permanent feature of Indian Constitution. That means it cannot be deleted, it cannot be abrogated, it cannot be modified. But BJP, which was in power at the center, which is in power in the center, it had 3 major important manifesto articles. 3 major objectives that BJP wanted to achieve. And they promised to the people of India, if we come to power with a solid majority, we will include 3 important things when we are in government. Number 1, we will take steps for the construction of the Ram temple at Ayodhya. Number 2, we will strive to enact uniform civil code for all the citizens of India. And third, we will abrogate Article 370. So abrogation of Article 370 was high on the list of priorities for the BJP, because every political party has an ideology. BJP had this ideology, and that is why they wanted to get rid of Article 370. Why? Because one of the founding leaders of Janasangh, initially it was Janasangh. Janasangh is the predecessor of the BJP. One of the important leaders of Janasangh was Mr. Mukherjee. Mr. Mukherjee, he had to come to Jammu and Kashmir, but at that time the process was you had to take the permission. Permit system was applicable. For those who are not the citizens of Jammu and Kashmir, if they had to enter Jammu and Kashmir, they needed a permit. And this permit was not given. Mr. Mukherjee tried to enter, Shama Prasad Mukherjee, he tried to enter Jammu and Kashmir. He was arrested because he entered without the permit. And then under mysterious circumstances, he died. He died inside the jail. His slogan was that in one country, we cannot have 2 constitutions, 2 heads and 2 flags. Because the country was one, but the constitution were 2. Constitution of India, Constitution of Jammu and Kashmir. Flags were 2, national flag and the flag of Jammu and Kashmir. No other state in India has a flag, has its own official flag. Unofficially, for example, Karnataka uses a flag. But officially, there is only one flag, which is the national flag. We have one head of the state, the president of India. We had the president, or what was called a Sadr-e-Riyasat in Jammu and Kashmir as well. So that was not something which was acceptable to Mr. Mukherjee, not acceptable to Janasangh, and later on not acceptable to the BJP. And then what happened? August 5, 2019. President was asked, please issue an order. What is that order? Please say through a public notification that all the provisions of Indian Constitution, without any exceptions, without any modifications, shall apply to the state of Jammu and Kashmir. That was the Presidential Order 272, and this Presidential Order of 272 replaced Presidential Order of 1954. President said, but how can I issue this order? Said, why? Because I need the concurrence of the state government. Yeah, so get the concurrence of the state government. Who is now the state government? There is no state government in Jammu and Kashmir. The Legislative Assembly has been dissolved. Why? Because there were elections in 2015. No political party got the majority. BJP and the PDP got together to form the government. Then after a few years, BJP withdrew support to the PDP government. The government collapsed. When there is no government, there is president's rule. When there is president's rule, who runs the state? The governor. So who is the state government now? The governor. Governor gave the concurrence, and all the provisions of Indian Constitution, without any exceptions, without any modifications, applied to Jammu and Kashmir. And through this presidential order of 272, Article 35, capital A, disappeared. How? Very simple. Can any other item mentioned in the union list be made applicable to Jammu and Kashmir? Yes. Can any other article of Indian Constitution be made applicable to Jammu and Kashmir? Yes. What is the process? President will issue an order. But this presidential order cannot be issued without the concurrence of the state government. Now what the president is doing? President is issuing an order. That order is known as Presidential Order 272. This order replaces the Presidential Order of 1954. And through this presidential order, the entire Indian Constitution is made applicable. Because till August 5, 2019, if there were 97 items in the union list consists of 97 items, 94 were already applicable to Jammu and Kashmir. Through various presidential orders, because I told you this presidential order has been modified multiple times. Initially, only 3 subjects, defense, external affairs, communication, were applicable to Jammu and Kashmir. Now, through this presidential order, which was modified multiple times, one by one, various other items in the union list were made applicable to Jammu and Kashmir. So that on the morning of August 5, 2019, 94 of the 97 items were already applicable to Jammu and Kashmir. Now, when the president issued an order, all those remaining 3 items also got applicable. That means entire 97 items got applicable to Jammu and Kashmir. Not the entire constitution was applicable to Jammu and Kashmir. Directive principles were not applicable, even on the morning of August 5, 2019. Fundamental duties were not applicable. Various other provisions of Indian Constitution were not applicable. Because previously only Article 1 and Article 370 was applicable. But through this presidential order, with the concurrence of the state government, citizenship chapter got applicable. Similarly, fundamental rights got applicable, but with exception of Article 35, capital A. Various other provisions of Indian Constitution, such as the emergency provisions, such as the Office of the Chief Justice of India, CAG, Finance Commission, Audit, Account, Election Commission of India got applicable to the state of Jammu and Kashmir. But even then, there were articles which were not applicable, even on the morning of August 5, such as Article 3 was not applicable, such as DPSPs were not applicable, fundamental duties were not applicable. But now the president is issuing an order. Entire Indian Constitution will apply to Jammu and Kashmir without any exception, because the exception was Article 35, capital A. This exception is also gone. That means every single provision of Indian Constitution is now applicable to Jammu and Kashmir. How? With the concurrence of the state government. And then something else happened. On August 6, another presidential order was issued by the President of India. Declaration under Article 370, Clause 3 of the Constitution of India. What is Article 370, Clause 3? Self-destruct clause was used. Notwithstanding anything contained in the foregoing provisions, this article shall cease to exist or will exist with such modifications and exceptions as the President may by order specify. But for that, the concurrence of the Constituent Assembly of Jammu and Kashmir is necessary. But this presidential order says, in exercise of the powers conferred by Clause 3 of Article 370, President, on the recommendation of the Parliament, is pleased to declare that from August 6, all the clauses of Article 370 shall cease to be operative except the following. Now, Article 370, which had Clause 1, Clause 2, Clause 3, now will have only one clause. And what is that? All provisions of this Constitution, as amended from time to time, without any modifications, without any exceptions, shall apply to the state of Jammu and Kashmir. That means now entire Indian Constitution is made applicable. Previously, it had various clauses. All those clauses are gone. Only Article 370 remains. But how was this done? This was done with some painstaking work on the interpretation of the Constitution. How? Number one, there is no Constituent Assembly in Jammu and Kashmir, because Constituent Assembly of Jammu and Kashmir was abolished in 1956. Just like the Constituent Assembly of India was done away with 1949. Because what is your job? To draft a constitution, to get the constitution enacted. Once the constitution is done, what is your job? Abolished. The Constituent Assembly of India was done away with. The Constituent Assembly of Jammu and Kashmir also was done away with. So in 1956 now, from 1956 onwards, there is no Constituent Assembly. That used to be the argument of the people who would say that Article 370 was temporary till 1956, permanent afterwards. What was the purpose of the Constituent Assembly of Jammu and Kashmir, as promised by the Government of India? That you have to draft your own constitution, and your constitution will define the relationship between the state and the Union of India. Till that time, we will have a temporary provision known as Article 370. And Constituent Assembly, you then decide what should happen to this Article 370 because you have the power. But Constituent Assembly, when it gave Jammu and Kashmir its constitution, it did not recommend anything on Article 370. One interpretation is, when it did not recommend anything on Article 370, it means they wanted Article 370 to continue. Or the other interpretation is that once Article 370 is made temporary, after the Constituent Assembly is gone, Article 370 should also go. But there is no Constituent Assembly, and that is the wording of Article 370, Clause 3. Provided that the recommendation of the Constituent Assembly referred to in Clause 2 shall be necessary. Without this, you can't do it. When there is no Constituent Assembly, we need to do something. And for that, Article 367 was modified. What is Article 367? It talks about interpretation of the Constitution. For example, Constitution mentions scheduled tribes, scheduled castes. But who are these scheduled tribes? Who are these scheduled castes? We need to define them. We need to interpret them. That interpretation is added through Article 367. And now there is Constituent Assembly of Jammu and Kashmir. But there is no Constituent Assembly. What government asked the president to do? Issue Presidential Order of 272 on August 5, 2019. Please use Article 367 to modify Article 370. How can I do that? You issue an order, and through this order, any provision of Indian Constitution will be made applicable to Jammu and Kashmir. Yes. So we have a governor there who is the state government. So take the recommendation of the governor and modify Article 367. How? Say Constituent Assembly, which is mentioned in Article 370 of the Constitution, means or should be interpreted as Legislative Assembly of Jammu and Kashmir. We have a term called Constituent Assembly mentioned under Article 370. But there is no Constituent Assembly right now. When there is no Constituent Assembly right now, that means we have to interpret what is this Constituent Assembly. For that, President, you issue an order, modify Article 367, or use Article 367 to interpret Article 370. Article 367 is interpretation of the Constitution. There is something known as Constituent Assembly of Jammu and Kashmir in Article 370. Use Article 367 to say that Constituent Assembly mentioned in Article 370 is nothing but Legislative Assembly of Jammu and Kashmir. Which means now, on the recommendation of the Legislative Assembly of Jammu and Kashmir, you can delete, modify Article 370. The next morning, Presidential Order of 273 was issued. What does this Presidential Order says? It says, on the recommendation of the Parliament, I am modifying Article 370. Every other provision of Article 370 is gone. Only this provision remains. But how can on the recommendation of the Parliament? Because Constituent Assembly's interpretation has now been changed to Legislative Assembly. But there is no Legislative Assembly in Jammu and Kashmir because the state is under President's rule. When the state is under President's rule, who has the power to make a law on Jammu and Kashmir? Parliament. That means Parliament is the Legislative Assembly of Jammu and Kashmir. That means now the President, on the recommendations of the Parliament, which is the Legislative Assembly of Jammu and Kashmir, which is the Constituent Assembly in Article 370, has now modified Article 370, and Article 370, all other provisions gone, only this provision remains. That is how this Article 370 was first modified. Modified in the sense, all provisions of Indian Constitution were made applicable to Jammu and Kashmir. But when all provisions of Indian Constitution were made applicable, there was still Article 371. There was still Article 372. There was still Article 370 Clause 3. Now the government said, we don't need all these provisions. We just need one provision. That entire Indian Constitution, without any exceptions, as amended from time to time, is applicable to the state of Jammu and Kashmir. That's how Article 370 was modified. Which means Article 370 was not abrogated. Abrogation would have been Article 370 is no longer there in the Constitution. It is still there, but without any power. Because the only provision which remains is entire Constitution is applicable to Jammu and Kashmir. That is Article 370. Any questions? Let me know. This implies there was an exception to concept of dual citizenship in India. Yes. Whether this was done rightly or wrongly, constitutionally, unconstitutionally, legally, illegally, that is for the Supreme Court to decide. There is a petition which the Supreme Court, 5 judges of the Supreme Court, headed by the Chief Justice of India, has heard. All the arguments are complete. This matter has been reserved for judgment. At any point in time, we will see the Supreme Court issuing a date saying on this particular date, we will give the verdict on Article 370. How President amended Article 367 through presidential order. That is why some constitutional experts say Article 370 was not the special status for Jammu and Kashmir. Article 370 was the special status for Delhi. Because if for any other state, Article 367 was to be used or modified, you needed Article 368 to amend the constitution. But for Jammu and Kashmir, all you need to do, President issuing an order with the concurrence of the state government. Because previously Article 1 and Article 370 are applicable. Now, can you use Article 367? Yes, by the presidential order with the concurrence of the state government. But there is one thing, whether Supreme Court will agree to that or not, that remains to be seen. Ideally, Article 370 was to apply other provisions of Indian Constitution to Jammu and Kashmir, other provisions other than Article 1 and Article 370. If the President issues an order under Article 370 saying Article 367 is to be modified, but in reality he is modifying Article 370 itself, this cannot be allowed. This is wrong, because Article 370 can be used to add or to extend other provisions of Indian Constitution to Jammu and Kashmir. How can this phrase, other provisions of Indian Constitution, other than Article 1 and 370, also mean that you're amending Article 367 to amend Article 370? Article 370 can be used to add other provisions, not to modify itself. But whether court will agree to that or not, we'll have to wait and watch. Another issue is, okay, just one last thing, otherwise we will be done with this. Once the judgment comes, we will have an elaborate discussion on this in a current affairs discussion. Article 370 was modified by the Presidential Order of 1954 with the concurrence of the state government, right? Now, who is the state government? Governor. Listen to me carefully. There's something beautiful. Now, whether the court will agree to this or not, we'll have to wait and watch. When President's rule was applied to Jammu and Kashmir, in President's rule, which we will discuss after this, in President's rule, we say President will issue an order, a proclamation, and all the powers that are available with the state government will be taken by President. Listen to me carefully. All the executive powers that are with the state will be taken by the President. That is what we call the President's rule. That is what the President proclaims. Which means when the state is under President's rule, all the executive power is with President. What is the power with the governor? Nothing. Governor has all the powers, all the executive powers, when there is an elected government in place. So the Chief Minister and Council of Ministers, they will exercise their powers, but basically it will be in the name of the governor. So governor has all the powers. If the state was not in the President's rule, then governor would have given some recommendation, some concurrence. That is okay, that is acceptable, because governor has that power. All the executive powers are with the governor. But there is no government, there is no Council of Ministers, there is no Chief Minister. And now the state is under President's rule. So if I am the governor, the state is under President's rule, all my powers will now shift to President. When all the powers shift to President, that means the governor of the state has no power of his own. So what did the governor recommend as the state government on August 5, 2019 to issue Presidential Order of 1954? To issue the Presidential Order of 2019, Presidential Order 272, which means when the first Presidential Order on August 5, 2019 was issued, it said the President, on the recommendations of the state government. But there is no state government. Yes, there is a governor. when there is a governor. But the point is, governor does not have the power. Governor has shifted all the power to the president. So when there were no powers to the governor, what did he recommend to the president? On what grounds? On what logic? Because you don't have the power. All your powers have been shifted to the president. Then president could have said, I, as the president of India, on the advice of myself, on the advice of the president itself, can issue this order, which cannot happen. But whether the court will accept the reasoning or not, let's wait and watch. What was Governor Satyapal Malik's statement on this? Governor Satyapal Malik said, I don't know anything. I was told in the morning to sign on this. I was told in the evening before that you will receive something. Open it on the morning of August 5, sign it and give it to the president. I just signed it. On this ground, although Mr. Satyapal Malik is not answerable in any court of law while discharging his official duties because the governor has the immunity, it appears if Mr. Satyapal Malik would have been asked to appear before the court and give an affidavit that I did exactly this, it clearly means that there was non-application of mind in giving this recommendation to the president. When there is non-application of mind, that means it's an arbitrary decision. When it's an arbitrary decision, it goes against Article 14 of the Constitution. But since the governor was not asked to appear before the court, this argument is invalid. Okay. Now let's look at emergency provisions, and we will have to discuss Article 352, Article 356, Article 360 of the Constitution. Article 352 talks about national emergency. Article 356 talks about President's rule, and Article 360 talks about financial emergency. We are a federal polity. We have a federal constitution. And there are two important features of a federal constitution: dual government and distribution of powers. Clear? Australian constitution, which is also federal, can never become unitary. US constitution, which is also federal, can never become unitary. Indian constitution, which is federal, remains federal in normal circumstances. The moment there is some abnormality, our constitution changes its form and becomes a unitary constitution. What are those features which convert Indian federal constitution into a unitary constitution? Those provisions are emergency provisions. Because during these emergency provisions, national emergency, president's rule, financial emergency, the government of a state has limited powers. The legislature of the state has limited powers, or in some cases has no power at all. So dual government, distribution of powers between the center and the state, which are two important characteristics of federal constitution, they are under strain during emergency provisions, which means it is these emergency provisions which convert our federal polity into a unitary feature. That is what we call emergency provisions. First, we will discuss what is national emergency, then we will discuss president's rule, then we will discuss financial emergency, then we will take a break, and then we will discuss various schedules of the Constitution. But what is the rationale behind having these emergency provisions? To safeguard unity, integrity, security of the country, the democratic political system, to safeguard the Constitution. If in a state constitution is violated, we will use emergency provision and convert federal polity into unitary polity. If there is a threat, danger to the unity, integrity, and security of India, if there is war, we will convert, using emergency provisions, our federal polity into a unitary polity. But this will only be for a temporary period. This won't be forever, because this is for emergency requirement. Once those conditions are gone, our constitution will again assume the shape of a federal polity. That means, in the name of, for the sake of unity, integrity, and security of India, to ensure the stability of our political system, to ensure that the constitution is followed in letter and spirit in India, we have these emergency provisions, which for temporary period convert our federal polity into a unitary polity. And first such provision is Article 352, National Emergency. How many times national emergency has been imposed in India? 3 times. First, 1962, when there was Indo-China War. Second, in 1965, when there was India-Pakistan War. Third, in 1970, second, in 1971, when there was India-Pakistan War, which led to the emergence of Bangladesh as an independent country. And third was in 1975. This was because of internal disturbance. And this is when Madam Gandhi was the Prime Minister, and this is considered to be the most controversial of all the national emergencies imposed. National emergency was imposed first in 1962 because of India-China War, then in 1971 because of India-Pakistan War, which led to emergence of Bangladesh. But now you would ask, sir, why not in 1965? Because in 1965 also there was a war between India and Pakistan. This emergency, which was imposed in 1962, was revoked in 1968. Which means during 1965 war, there was already emergency in place. So there was no need to impose another emergency, because this emergency was revoked in 1968. Then it was imposed in 1971. And these two emergencies are not controversial because they were done for legitimate reasons. But 1971 proved to be controversial. 1975 one proved to be controversial when it was imposed when Madam Gandhi was the Prime Minister in June 1975. And this time it was not done because there was a war. It was done because there was something known as internal disturbance. But what exactly is national emergency? Constitution says under Article 352, if the president is satisfied. But we know it is not the personal satisfaction of the president, because the president is a rubber stamp. He does not have, or she does not have, the real power. She exercises these powers only on the recommendations of the Prime Minister and the Council of Ministers. Which basically means if the president is satisfied, which means if the Council of Ministers headed by the Prime Minister are satisfied, then what the president can do? President can proclaim national emergency. But what should satisfy the president? If there is a war, if there is external aggression, or if there is armed rebellion, or anticipation of war, external aggression, or armed rebellion. What is the difference between war and external aggression? War is always declared. That means the two countries will declare war on each other. India will declare war on Pakistan. Pakistan will declare war on India. India will declare war on China. China will declare war on India. War is always declared. Israel has declared war on Hamas. It's always declared. if it is not declared by the states, if it is not declared officially by the governments, then it is external aggression. That means from external country, we have a threat to India's unity and integrity, where Pakistan may be sending its troops to India, launching an aggression, but without officially saying we are in a state of war. That is external aggression. But there can also be armed rebellion. Armed rebellion is something which happens within the territory of India, where the threat is internal. In war or external aggression, the threat is external. War is launched by an external enemy. External aggression, the threat is coming from beyond the borders of India. But in armed rebellion, the threat is coming from within the territory of India. Maybe within the territory of India, there are secessionists, there are Maoists, there are Naxalites who decide to take up arms and they want to overthrow the government in Delhi. That means there is an anticipation of an armed rebellion where people are rebelling in India, within the territory of India. The threat is not external, the threat is internal. National emergency can be imposed. But it is not that war should have broken, external aggression should have started, armed rebellion would have been initiated, and then president will proclaim national emergency. No. If the president is satisfied that there may be war, that means he's anticipating. There may be war, there may be external aggression, there may be armed rebellion, even in anticipation of the war. If the president is satisfied, then the president can impose national emergency. And this national emergency can be imposed in the entire country or a state or a part of a state. Which means it is not necessary that the emergency is imposed in the entire country. Emergency can be imposed only in a state or any part of that state as well. So what is national emergency? Has been imposed in India 3 times in the past. It says if the president is satisfied because of war or external aggression or armed rebellion, the president will impose national emergency. Maybe in the entire country or any part of the country, which means a state, or any part of that state as well. When emergency is imposed on the grounds of war or external aggression, we call it external emergency. When it is imposed on the grounds of armed rebellion, we call it internal emergency. But if the emergency is imposed today, for how long will it continue? Then we will look at what is the impact of national emergency. If the national emergency is imposed today, then within 1 month, which means within 30 days, both houses of the parliament shall have to approve national emergency by special majority. Let's say national emergency is proclaimed today, issued today, imposed today by the president. Then within 30 days of the imposition of national emergency, both houses of the parliament, Lok Sabha as well as Rajya Sabha, separately, they have to pass a resolution by special majority, which means 2/3 of the members present and voting, and approve this national emergency. If one house approves, the other house does not, national emergency is revoked. If both the houses do not pass a resolution by special majority, national emergency is revoked. But if both the houses pass a resolution by special majority approving this national emergency will continue for 6 months. Can it be extended further? Yes. Get the approval of the parliament again, and it will be extended for another 6 months. Can it be extended further? Yes. Get the approval of the parliament and extend it by another 6 months. That means every 6 months, you have to go back to the parliament, both houses of the parliament. If they pass a resolution by special majority, the president can extend national emergency for 6 more months, then for 6 more months, then for 6 more months. Is there any upper time limit? Can this national emergency be approved and continued forever and ever and ever, every time, 6 months at a time? Can this happen? Yes, there is no upper limit. Why? Because we don't know for how long the war will continue, for how long the external aggression would continue, for how long and till what time is the threat and the danger of armed rebellion in India. If the president is satisfied because of war, external aggression, or armed rebellion, what the president will do, impose national emergency. Not just in the entire country, or maybe in only a state, or maybe a part of that state. But if this national emergency is imposed today, for how long will it continue? Within 30 days of the imposition of national emergency, both houses of the parliament, by special majority, will have to approve this national emergency. If it is approved, it continues for 6 months. Can it be extended further? Yes. Get the approval of the parliament, extend it beyond 6 months. Can it be extended further? Yes. Get the approval of the Lok Sabha and Rajya Sabha by special majority, and national emergency is extended for 6 more months. Months. There is no upper limit because we don't know for how long there is a danger to the unity, integrity, security of India. But it can be revoked as well. How is the national emergency revoked? First option is president on the advice of cabinet. President imposes national emergency on the advice of the cabinet. President will revoke national emergency on the advice of the cabinet. Simple. At any time. Or if one of the two houses does not approve national emergency, one house agrees, other house does not, and there is no such thing as joint sitting. So you can't have joint sitting of both the houses of the parliament to approve national emergency. No. By that logic, the will of the Lok Sabha will prevail. National emergency should be approved by both houses of the parliament by special majority. If one house agrees, other house does not, national emergency has to be revoked by the president. Third, on the directions of the Supreme Court. If national emergency has been imposed, matter goes to the court, to the Supreme Court. In Supreme Court, we challenge the imposition of national emergency on the grounds of mala fide. If you can convince the Supreme Court that there was no need to impose national emergency, which means the intention of the president is bad, there was absolutely no need to impose national emergency. If the Supreme Court agrees, then on the directions of the Supreme Court, the president will have to revoke national emergency. Or fourth option, which is a special power given to Lok Sabha. What is that special power? Under Article 352, Clause 8, if Lok Sabha passes a resolution by simple majority disapproving national emergency, this resolution is binding on the president. President shall revoke national emergency. Because this resolution becomes what? Can anybody tell me what kind of resolution this would be? Statutory resolution. Very good. Because statutory resolution is binding on the government. A special power is given to Lok Sabha, not to the other house, only to LS, Lok Sabha. If it passes a resolution by simple majority, then it is binding on the president to revoke national emergency. So what is national emergency? How it can be imposed? We know that. How it can be revoked? We also know that. For how long will national emergency continue? We also know that. But what is the impact of national emergency? The impact is seen on fundamental rights. The impact is seen on state executive. The impact is seen on state legislature. What is the impact on fundamental rights? When external emergency is imposed, Article 19 gets suspended. That too automatically. When internal emergency is not internal emergency is imposed, Article 19's enforcement is not automatically suspended. What about other fundamental rights? Then under Article 359, other fundamental rights can be suspended except Article 20 and 21. National emergency is imposed on the grounds of war or external aggression. What sort of emergency is this? External emergency. As soon as external emergency is imposed, Article 19 is automatically suspended. Although we say fundamental rights are not suspended, their enforcement is suspended. What's the difference? Article 19 remains. All the fundamental rights remain. But on the grounds of violating these fundamental rights, you cannot drag the state to the court. Which means these fundamental rights are not enforced. Otherwise, what is the difference between fundamental rights and directive principles? Fundamental rights are enforceable. Directive principles are not enforceable. That means if your fundamental rights are violated, you approach the Supreme Court will protect your fundamental rights. But during national emergency, when external emergency is imposed, Article 19 is suspended. If during this period your Article 19 is violated, you cannot approach the court. And it is normal as well. Article 19 says you have the right to assemble without arms at a public place. But there are bombs falling from the sky because there is war, there is external aggression. Your fundamental right needs to be restricted. No, I want to organize a rally. I want to move freely throughout the territory of India. I want to move freely to a state where there's a war going on between the two countries. No, my fundamental rights should not be enforced during this period. Why? Because forget about your fundamental rights now. Let's talk about ensuring the unity and integrity of India. First, the nation should remain. First, the nation should survive. Then you enjoy all your fundamental rights. Right now, please don't. The moment external aggression is imposed, external emergency is imposed, Article 19 is automatically suspended. But then what about other fundamental rights? President will issue an order under Article 359 on the advice of the government that Article 25 is also suspended. Your religious right. Public Article 16, Article 15, all fundamental rights can be suspended, which means their enforcement can be suspended, except Article 20 and 21. Even during emergency, you can't suspend Article 20 and 21, which means if your right to life has been violated, you can still drag the state to the court. Which means even during national emergency, it is not that the judiciary will punish you for same offense multiple times. It is not that during national emergency, the parliament will pass a criminal law and give it a retrospective effect. That is something that can't happen. But when the emergency is imposed on the grounds of armed rebellion, which is internal emergency, then Article 19 is not automatically suspended. Which means if it needs to be suspended, then President will issue an order under Article 359 and suspend Article 19. Then issue an order and suspend all fundamental rights except Article 20 and 21. So during national emergency, the first and the foremost effect of national emergency, impact of national emergency, is on fundamental rights. Then there is an impact on state executive. What is the impact? We have dual government, which means government in all the states and government at the center as well. We have state legislature, wherein we can say that we have distribution of powers. States can make a law under state list. Parliament has the power to make a law on union list. When national emergency is imposed, Parliament enjoys concurrent power to legislate on state list. Listen to me carefully. Understand the expression, because when you write these words, Parliament enjoys the concurrent power to legislate on state list, it becomes a beautiful statement wherein you are explaining everything. Otherwise, you had to write Parliament also has the power to make a law on state list, while the state legislature also has the power to make a law on state list. This becomes a big two statements. You just have to write it in one line so that it conveys everything. We have union list. Who has the power to make a law on union list? Parliament. We have state list. Who has the power to make a law on state list? State legislature. We have concurrent list. Who has the power to make a law on concurrent list? Both Parliament as well as state legislature. During national emergency, all the items mentioned in the state list, we get a sense, we assume that all these items are in the concurrent list. That means both Parliament as well as the state legislature can make a law on state list. That means on law and order, on land, on agriculture, on police, on all these items, Parliament also has the right to make a law. Otherwise, only state legislature had the right. That means there is no such thing as distribution of powers during national emergency. But this is for temporary period. Once Parliament passes a law, this law is passed on the state list. Let's say police. This law continues till the 6 months after the revocation of national emergency. For example, there is national emergency. Parliament is making a law on police, which is a state subject, but I can make a law right now. State legislature can also make a law, but I can also make a law. I am the Parliament. which means my law will prevail over the state law. Done. And this law, which is enacted on the state list, will continue as long as national emergency is in place. If national emergency is revoked today, this law will continue for a further period of 6 months. After that, it lapses. That means this is only for a temporary period because we have a danger to the unity, integrity, security of the state. Which means during national emergency, legislature is not suspended. In fact, parliament is not suspended. Parliament functions, legislature also functions, but legislature is brought under the ultimate control of the parliament. And in fact, during national emergency, the life of legislature is extended 1 year at a time. Sir, what does that mean? We are in a state of national emergency. In this state, can we hold elections? No. But the term of Lok Sabha is 5 years. The term of the Legislative Assembly is 5 years. But we can't hold elections. We can't organize elections. During national emergency, the term of Lok Sabha can be extended. The term of the legislature can also be extended 1 year at a time. That means the term was 5 years. Now the term becomes 6 years. In 6th year also, elections can't be conducted. Extend by another 1 year, 7 years. Extend by another 1 year, 8 years. That means during national emergency, the term of the legislature, the term of the Lok Sabha can be extended 1 year at a time. Something hilarious. What is the term of the Legislative Assembly in India? 5 years. Do you know Jammu and Kashmir was the only state in India where the term of the Legislative Assembly was 6 years? How is that possible? According to Article 370, any amendment of the Indian Constitution will not be applicable to Jammu and Kashmir without the concurrence of the state government. Clear? During emergency of 1975, Parliament amended the constitution and said the term of the legislature, the term of the Lok Sabha also will be 6 years. Not 5 years, we are extending it to 6 years. There was a government in Jammu and Kashmir. They said it is good. The term of the Legislative Assembly is also extended to 6 years. We are giving our permission. This constitutional amendment will apply to us as well. That means for our Legislative Assembly, the term will be extended to 6 years. Then in 1978, Janata Party came to power. Janata Party said, no, we can't have the term 6 years. We will go back to 5 years. So now another constitutional amendment act was passed. The term of the Lok Sabha was reduced from 6 to 5 years. The term of the legislature was reduced from 6 to 5 years. But the government of Jammu and Kashmir said, we don't agree with this amendment. When we don't agree with this amendment, that means we will not apply this amendment to us. That means our previous situation continues, which means instead of 5, only for Jammu and Kashmir, the term of the Legislative Assembly was 6 years. But be that as it may, the point is, during national emergency, the term of the legislature can be extended 1 year at a time. Clear? What about state executive? Normally, Chief Minister and his Council of Ministers, they perform their own task. There was a bomb blast yesterday, unfortunately, in Kerala. If you read today's the Indian Express newspaper. Now, Mr. Amit Shah has also spoken to the Chief Minister of Kerala. But can Mr. Amit Shah interfere with the government of Kerala? No. Why? Because you have dual government. One government in center, one government in the state. But if national emergency is imposed, the state government is kept under control of the central government. That means central government will issue directives to the state government. These directives are binding. Normally, and we will discuss in center-state relations, there are certain directives which are binding on the state. but not all. That means sometimes there can be an advice by the central government to the state as well. But during national emergency, every directive of the center is binding on the state, whose job is to appoint the Director General of Police, state. So you are tomorrow appointed as the Director General of Police of Uttar Pradesh. Now national emergency has been imposed. Government of India will tell the Chief Secretary of Uttar Pradesh that remove this person as the DGP, appoint this person as the DGP. It has to be changed. It has to be done. It has to be accepted. If not, the UP government would be dismissed. Didn't we discuss this in unitary feature of the Constitution? That the states are created and abolished based on the will of the center. At any point in time, the state can be created, state can be abolished. That's the feature of the unitary constitution. That means during national emergency, our federal constitution becomes like a unitary constitution. If the state government does not agree to your recommendation, does not agree to your directive, you can dismiss that state government. And the legislature is kept under check, or the legislature's powers are removed in such a manner that parliament assumes the concurrent power to legislate on state subjects. This is what happens during national emergency. Long story short, what is national emergency? Under Article 352, if the president is satisfied because of war, external aggression, or armed rebellion, the president can proclaim national emergency. Once proclaimed, within 30 days, it needs to be approved by both houses of the parliament by special majority. Once approved, it continues for 6 months. Can be extended again with the approval of the parliament by special majority. Can be extended again for another 6 months with the approval of the parliament. Can be extended for any number of years, but for every 6 months, you have to seek the permission of both the houses of the parliament. It can be revoked at any point in time by the president. It can be revoked if one of the two houses do not approve. It can be revoked if the Supreme Court says this was done wrongly, there was no need, no justification to impose national emergency, or a special power is given to Lok Sabha under Article 352, Clause 8. What if Lok Sabha was not in session? Then 50 members will have to write to the president. Members of the Lok Sabha will write to the president that please call a special sitting of the Lok Sabha because we have to discuss national emergency. If the session of the Lok Sabha is ongoing, these members will write to the speaker, dear speaker, let's have a discussion on national emergency. And if a resolution is passed by Lok Sabha by simple majority, then it becomes a statutory resolution. It is binding on the president to revoke national emergency. And what is the impact? The impact can be seen on fundamental rights, where Article 19 or any other article's enforcement can be suspended, except Articles 20 and 21, where Parliament assumes the concurrent power to legislate on state list, where every directive of the center is binding on the state, which means the state executive, state legislature is at the mercy of the center, converting our federal polity into a unitary polity. That is national emergency. But I told you that Keshavananda Bharati judgment was the one which saved and preserved India's democracy. In the similar fashion, we can say 44th Constitutional Amendment Act of 1978 prevented the misuse of Article 352. How Article 352, its misuse was prevented because of 44th Constitutional Amendment Act 1978? 1975, Srimati Indira Gandhi was the Prime Minister. President imposed national emergency. On what grounds? Internal disturbance. There was a judgment of the Allahabad High Court, which we have discussed, which disqualified Indira Gandhi as the Prime Minister from the Lok Sabha. Matter went to the Supreme Court, but maybe the government anticipated that maybe Indira Gandhi would be disqualified. On the advice of her advisors, she imposed national emergency. She asked the president to impose national emergency. Why? Because there was something known as the Sampurna Kranti revolution. Total revolution campaign was launched by Jai Prakash Narayanan from Bihar. Initially, it was led by the students in Gujarat, then traveled to Bihar, then traveled in different parts of the country. It was a movement against corruption. And when there were these protests and rallies of Sampurna Kranti, total revolution launched by JP, this, Madam Gandhi said, amounts to internal disturbance. And on the grounds of internal disturbance, she advised the president, please impose national emergency. After national emergency, Janata Party came to power and it promised the people that we will undo the damage to the constitution made by Mrs. Gandhi during emergency. And they had the eyes set on how do I prevent the misuse of Article 352? How should we ensure that after 1975, we will never see the misuse of Article 352? Constitution was amended, 44th Constitutional Amendment Act, 1978. This term, internal disturbance, which is very vague. Anything can be internal disturbance. There are protests, internal disturbance. There is stone pelting, internal disturbance. But this internal disturbance was replaced with armed rebellion. Now, unless and until there are people who raise arms, who through armed rebellion, who through the use of force want to overthrow the state, we cannot impose emergency. So internal disturbance was replaced with armed rebellion. That is one thing that has happened that has prevented the misuse of Article 352, which means after 1975, national emergency has never been imposed. Second change which happened, oral advice changed to written advice of cabinet. When in 1975 emergency was imposed, it was imposed by the president on the oral advice of the prime minister. Because constitution only said national emergency can be imposed by the president on the advice of the prime minister. And prime minister unilaterally on her own gave the advice to the president. But who is the prime minister after all? You don't have any independent power. We have a cabinet form of democracy where cabinet has to take a decision, and then this collective decision of the cabinet should be communicated to the president. It was argued that Prime Minister Mrs. Gandhi advised the president without consulting the cabinet colleagues. After the emergency was imposed, next morning she is asking for a cabinet meeting, inviting the cabinet ministers for the meeting, and there she is informing them, do you know what? Emergency has been imposed. But nobody could challenge her at that time. But in 1978, 44th Amendment, this was specifically done away with. From now onwards, President can impose national emergency only on the written advice of the cabinet. Previously, national emergency once imposed could continue forever. Till revoked by president. Just like in 1962 when it was imposed, it was revoked in 1968. That means national emergency was once imposed, it could continue forever and ever and ever unless and until revoked by the president. This was replaced with 6 months' approval, which is what is known as periodic parliamentary control. What is this periodic parliamentary control? Now the parliament will approve this national emergency only for 6 months. Then if you want to extend it further, get our approval again. Want to extend it further, get our approval again. Want to extend it further, get our approval again. So that parliament can keep a check on this power of the executive. Every 6 months there will be review, whether there is a need to continue national emergency or not. It should not be like previously. Once imposed, it continues forever and ever and ever unless and until revoked by the president. No, it cannot. Periodic parliamentary control. That is change number 3. Change number 4. Simple majority ratification changed to special majority. Previously, once imposed, national emergency was to be approved by both houses of the parliament by simple majority. Now in 1978, this simple majority ratification was changed to special majority. Now both the houses will have to approve national emergency by special majority, by a tougher majority. Fifth, ratification was required within 2 months. Changed to 1 month. Previously, once national emergency was imposed, it should have been approved by both houses of the parliament by special majority within 2 months. In 1978, it was changed. Now, both houses of the parliament shall have to approve national emergency by special majority, but within 1 month. Previously, all fundamental rights, their enforcement was suspended. 1978, changes made were except Article 20 and 21. Previously, during national emergency, all fundamental rights enforcement could have been suspended, including Article 20, including Article 21. But now, because of the 44th Constitutional Amendment Act, now the fundamental rights, except Article 20 and 21, their enforcement can be suspended. Under no circumstance can Article 20 and 21, their enforcement be suspended, even during national emergency. So this national emergency, which was misused in 1975, how do we prevent the misuse of this national emergency? For that, Parliament has enacted a law, amended the Constitution, 44th Constitutional Amendment Act, 1978. And all these changes, all these modifications made has prevented the misuse of Article 356. And there is a judicial review. If you think that Article 352 has been misused, there was no need to impose national emergency, you can drag the state to the court saying there is a malified intention on part of the president to impose national emergency. There was no need, no justification to impose national emergency. That is Article 352. Any questions? This power of judicial review, that judiciary can review the imposition of national emergency, it was provided in 1978. It was not a provision before. What if state assembly is dissolved during emergency? Can it be extended? State assembly need not be dissolved because its life can be extended 1 year at a time. So during COVID-19 lockdown in the entire country, why it is declared as national emergency? National emergency was not declared during COVID. If the next year is election and to avoid being defeated in the upcoming election, the government suppose apply emergency, would it be held valid? Because this would halt the elections and the current government will remain in power. If there is no need, if there is no war, no external aggression, no armed rebellion, the government will be asked by the Supreme Court, tell us what justifies national emergency. If there is no justification, if there is no proof, if there is no requirement, national emergency will be revoked. And this Article 352, Clause 8, which talks about a special power of Lok Sabha. This was also introduced during the 1978 amendment, 44th amendment, that now Lok Sabha will have a special power. If Lok Sabha passes a resolution by simple majority, it becomes binding on the president to revoke national emergency. Every 6 months, approval is to be taken. Now, while emergency is an operation only in any part of territory of India, during national emergency, center's executive power extends to states as well. What is the executive power? Basically, the governor of Karnataka, the government of Karnataka, their executive power extends throughout the territory of Karnataka. Clear? That means how the police is appointed, who is transferred where, how the schemes are run, how the law and order is maintained in Karnataka. That is the responsibility of the state government. But if there is national emergency, this can be the responsibility of the center as well. Center will issue directives to the states. Who will be the DGP? Transfer that police officer, ensure law and order in this area. Clear? So now the center also has the executive power in Karnataka. But the national emergency may not be imposed throughout the country, may be imposed only in a state or any part of that state. Does that mean executive power of the center will be extended only to that state, only a part of that state? No, it can extend to any other state which is connected. Connected in the sense, let's suppose national emergency is imposed in Rajasthan or any part of Rajasthan which shares border with Pakistan. But there are neighboring states as well. Executive power of the center can extend to these neighboring states as well. Why? We can tell the police, the state government in UP, not in UP, the state government in Gujarat, that you take these decisions. That means the center's executive power is extended to Gujarat as well. Why? Because Gujarat is closer to Rajasthan. It can extend to any state other than the state in which or any part of which the proclamation of emergency is in operation. Long story short, emergency is in Rajasthan or any part of Rajasthan which shares border with Pakistan. Normally, it should have been that central government will issue directive to Rajasthan government. Only Rajasthan government, because emergency is only in Rajasthan, not in other states. But during national emergency, the executive power of the center can extend to any other state also. Even if in those states, emergency is not imposed. Because we may need to provide directives to Rajasthan as well, to other neighboring states as well, to Punjab as well, to ensure that this threat from the external enemy is contained. That is national emergency. and that is Article 352. But Keshavananda Bharati judgment came in 1973, so judicial review became part of the constitution, and emergency is against the federal structure of the constitution. Is emergency against the federal structure of the constitution? No. Why? Because this is part of the constitution itself to protect the unity, integrity of India. And it is also meant to be for a temporary period. Once national emergency is over, once war is over, we will go back to a federal polity. That is why our constitution is amphibian in character, sometimes federal, sometimes unitary. In normal circumstances, it's federal. In abnormal circumstances, it is unitary. Keshavananda Bharati judgment came in 1973. So judicial review is part of the basic structure. Absolutely right. But in Keshavananda Bharati judgment, Supreme Court did not say judicial review is part of the basic structure. Supreme Court said there is something called basic structure, which you cannot touch, which you cannot change, you cannot alter. Judicial review as part of the basic structure, that was told by the Supreme Court in 1980 in Minerva Mills case. Minerva Mills case in 1980 said judicial review is part of the basic structure of the Constitution. In 1973, Supreme Court said there is something called basic structure. Rule of law is part of the basic structure. But judicial review, is it part of the basic structure? That was told by the court in 1980 in Minerva Mills case. Jalak, difference between Article 352 and Article 144. I think you're talking about Section 144 of Criminal Procedure Code or Indian Penal Code, where the assembly of more than 5 people is banned. That is Section 144. Okay. Now let's look at President's rule. Or do we need a break before that? Yes, yes, no, 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 yes, 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 as per your choice. No, yes, yes. Okay. 7. Let's meet 7:55 a.m. See you on the other side of the break. Now let's look at President's rule under Article 356 of the Constitution. When this provision was being debated in the Constituent Assembly, Dr. Ambedkar hoped that this Article 356 would remain a dead letter in the Constitution. Dead letter in the sense, although this provision will be there in the Constitution, but it will not be used. It will not be employed. It will remain like a dead letter in the Constitution. But one provision of the Indian Constitution which has been used, overused, abused, hyperused has been Article 356 of the Constitution. What is this Article 356? What happens because of Article 356? What is the validity of Article 356? And how can we prevent the misuse of Article 356? Let's discuss. Constitution says, number one, under Article 355, that it shall be the duty of the union, of the central government. What central government, what the union government has to do, it has a duty. What is that duty? Two important duties. One, it has to protect every state against external aggression, against internal disturbance. That means every state is to be protected by the union from external enemy, from internal disturbance. That's the duty. And duty number two, it also has to ensure that the government of every state has to be carried out in accordance with the Constitution. If there is one constitution for the entire country, but there is a state which is not abiding by the Constitution, which is violating the Constitution, it shall be the duty of the center, union, to ensure that Constitution is followed in every state. If not, something will happen and President's rule will be imposed. So it shall be the duty of the union to ensure, to protect every state from external aggression, from internal disturbance as well, and to ensure that every state is being carried out according to the provisions of the Constitution. If not, then the president may, by proclamation, what the president will do, president will issue a proclamation. And through this proclamation, what it will do, what the president will do, all the executive powers of the state will be taken over. Which means the first casualty in a president's rule is chief minister and council of ministers, they're dismissed. All the executive powers of the state are vested in the governor. There shall be council of ministers with chief minister at the head to aid and advise the governor, because all the executive powers are with the governor. When the president proclaims president's rule in a state, the first thing that happens, chief minister and council of ministers are gone, they're dismissed. Now, who will exercise the executive powers? President directly, through his agent, who is the governor. That means president can assume to himself all the functions of the government except the legislature of that state. You can't take over the legislative powers of the state, you can take over the executive powers of the state. But the president in his proclamation will declare that all powers of the legislature will be exercisable by or under the authority of the parliament. Executive powers will be assumed by the president to herself. What about the legislative powers of that state? The president in her proclamation will declare that all the legislative powers will now go to the parliament. During president's rule, president can make a proclamation and suspend whole or any operation of this constitution relating to any body or authority of the state. Which means when this presidential proclamation is issued by the president, maybe what the president will say, that there is an authority in that state, let's say the State Information Commission. let's say the State Accountability Commission, let's say the state police, let's say any authority of the state, we will suspend those provisions because now center will assume all the control and charge of that state. This presidential proclamation, how is it issued? Constitution says under Article 356, if the president is satisfied on the basis of the report of the governor or even otherwise, what will happen, what will be mentioned in this report? That in this state there is a breakdown of constitutional machinery. What the president can then proclaim? President's rule, proclamation. Article 356 of the Constitution, President's rule, which Dr. Ambedkar hoped would remain a dead letter, will never be used, will never be employed, but it has been misused. And more than 111 times President's rule has been imposed in different states of this country since the commencement of the Constitution in 1950. Article 355 imposes two duties on this union, on the center. Duty number one, you have to protect every state from external enemy, from internal disturbance. Duty number two, you have to ensure that every state is being carried out in accordance with the provisions of the Constitution. In every state, Constitution should be followed. If Constitution is not followed, then we say it is breakdown of constitutional machinery. Then Article 356 will be applicable. Which means under Article 356, if the president is satisfied, and we know it is not the personal satisfaction of the president, it is the satisfaction of the cabinet, headed by the Prime Minister. But the report of the governor is important. If the governor submits a report, and in this report, the governor explains that in my state there is breakdown of constitutional machinery. If the president is satisfied by this report, that yes, indeed there is breakdown of constitutional machinery, president will proclaim president's rule under Article 356. And what will happen because of that? First, Council of Ministers dismissed. Chief Minister, you're gone. Your ministers are gone. All your executive power will now be taken over by me. I am the President of India. What about the legislative powers? That will be exercised by the Parliament. Parliament will become the legislature for that state. Which means no dual government because the government of the state is dismissed. No distribution of powers because now Parliament, which is the central legislature, will make laws on behalf of the state legislature. That is the impact of President's rule. But normally what happens is that the governor will submit this report. Governor will submit this report to the president. That, dear president, in my state there is breakdown of constitutional machinery and these are the reasons, which I will explain later. What are these reasons on the basis of which the president's rule can be imposed? That these are the reasons. I assume there is breakdown of constitutional machinery. Now the ball is in your court. You can proclaim president's rule. President will refer this matter to cabinet. Because president cannot take an independent decision. President refers this matter to the cabinet. And now the cabinet meeting will take place. Cabinet will discuss this governor's report. And ultimately, cabinet will advise the president, proclaim president's rule. And this advice is binding on the president. Why? Because there shall be council of ministers with prime minister at its head to aid and advise the president, who shall act on that advice. The president may refer this advice back, but only once. No, this is not a fit case of president's rule. Can you please reconsider? But if the same advice is given again to the president, there is no other option but for president to issue this proclamation under Article 356. Constitution says if the president is satisfied with the report of the governor or even otherwise, that means the report of the governor may also not be required. That means even otherwise, even without the report of the governor, the president can proclaim president's rule under Article 356. It happened in Tamil Nadu. Mr. Karunanidhi was the chief minister. The governor did not submit any report saying there is breakdown of constitutional machinery. Even then, the president was satisfied, even without the report of the governor, that there is breakdown of constitutional machinery in Tamil Nadu. Government was dismissed. President's rule was imposed in the 1991. And once this president's rule is imposed, if this president's rule is imposed today, then within 60 days, which means within 2 months, both Lok Sabha and Rajya Sabha shall have to approve president's rule by simple majority. Both Lok Sabha and Rajya Sabha separately will have to pass a resolution by simple majority, but within 60 days of the proclamation of president's rule. If it is approved by both houses of the parliament separately, president's rule continues for 6 months. Can it be extended further? Yes, for another 6 months. Can it be extended further? Yes. But if 2 conditions are satisfied. Condition number 1, national emergency is in place in any part of that state. Or entire state. Or number 2, if the Election Commission of India certifies that no elections can be held. If one of these 2 conditions are satisfied, then this president's rule can be extended for another 6 months, then another 6 months, then another 6 months, then another 6 months. That means for total of 2 years. Plus 1 year originally, which means the maximum constitutional validity of president's rule is 3 years. If president's rule is imposed today, then within 60 days, both Lok Sabha and Rajya Sabha will have to pass a resolution by simple majority of the members present and voting. If it is approved by both houses of the parliament, president's rule continues for 6 months. Can it be extended further? Yes. Get the approval of the parliament again by simple majority. President's rule can be extended for 6 more months. That means total for 1 year. Can this president's rule in a state be extended beyond 1 year? Yes. But only and only if one of these 2 conditions are satisfied. If either national emergency is in place in the entire state or any part of that state, then president's rule will continue. Or If the Election Commission of India certifies that in this current security scenario, in existing situation, it is not possible to hold elections, it is not possible to organize elections, then the president's rule can continue for 6 more months, then 6 more months, then 6 more months, then 6 more months, but only for a maximum of 2 more years. That means the maximum constitutional validity of a president's rule is 3 years, mentioned in the constitution. But in Punjab, president's rule was extended for 6 years, for 5 years, first for 4 years, then for 5 years. How is that possible? Because if you want to extend president's rule in a particular state beyond 3 years, then constitutional amendment is required. If the constitution says something, but you go against the constitution, you can't do that. The only way you can do that is change the constitution. If the constitution says maximum validity of president's rule is 3 years, subject to 2 conditions, if you want to go beyond 3 years, then you have to change the constitution. And for Punjab, constitution was changed. 3 years for Punjab means 4 years. Then even in 4 years, condition was still not normal because there was Khalistani uprising in Punjab in the 1980s after the attack after the Operation Blue Star. Then even in 4 years, situation did not materialize, situation did not become normal, it was not possible for election commission to organize elections. Then president's rule was extended beyond 4 years for 5 years, but constitution was amended. For Punjab, 3 years, if it is the limit, means 5 years. But for Jammu and Kashmir, president's rule continued for 5 years, 6 years as well, and no constitutional amendment act was required. Why? Because for J&K, previously, there used to be governor's rule for 6 months under section 92 of J&K constitution. That means for Jammu and Kashmir, previously, there used to be a provision known as governor's rule. Governor's rule could be imposed for 6 months. If there is a breakdown of constitutional machinery, but the constitutional machinery according to the constitution of Jammu and Kashmir. But once this 6-month period is over, then Article 352 will be applicable to Jammu and Kashmir. And there is no upper limit to the time of Article 352 in J&K. When the president proclaims president's rule for Jammu and Kashmir under Article 356, there is no upper limit. That is why president's rule continued beyond 5 years, 6 years in J&K as well. That was prior to 2019, not now. That was prior to 2019 when J&K had a special status. That is why I told you previously that if it was viewed as the special status for Jammu and Kashmir, in fact, it was the special status for Delhi. It was the special status for the central government. Because to amend any provision of the constitution for a state, you need constitutional amendment. But for J&K, you just needed a presidential order. To extend president's rule beyond 3 years, for Punjab, you had to amend the constitution twice. But for J&K, you can do that only by a presidential order. But be that as it may, at any point in time, this president's rule can also be revoked. This is where your Lakshmikant needs to be corrected. It can be revoked at any time by the president only on the advice of cabinet. There is a table in Lakshmikant book where national emergency and president's rule is compared. And under national emergency, it is said that national emergency can be revoked by the president only on the advice of the cabinet. But president's rule can be revoked by the president at any time. Not correct. President's rule is imposed by the president on the advice of the cabinet. President's rule can be revoked by the president only at the advice of the cabinet, not on her own. There is no discretion when it comes to president's rule for the president of India. Can be revoked if either or both houses do not approve president's rule. Can be revoked on the directions of the court. If the High Court or a Supreme Court says that this president's rule was not needed, it was illegally, arbitrarily applied, president's rule can be revoked. Clear? So what is president's rule basically? If the president is satisfied on the report of the governor or even otherwise that there is a breakdown of constitutional machinery, president's rule can be proclaimed. Once president's rule is proclaimed, it has to be approved by both houses of the parliament within 60 days by simple majority. Once it is approved, it continues for 6 months. Then can be extended further beyond 6 months for 6 more months, but on the approval of the parliament. Can it be extended beyond 1 year? Yes, but every time you have to extend it only 6 months. 6 months, then 6 months, then 6 months, then 6 months. That means total 2 years, provided one of the two conditions are satisfied. Either national emergency is in place, is in operation, or the Election Commission of India certifies that under the current scenario, we cannot hold elections. It is not possible to hold elections. But 3 years is the maximum constitutional validity of a president's rule. If you want to extend president's rule beyond 3 years, Parliament needs to amend the constitution. But it can be revoked at any point in time by the president on the advice of the cabinet. It can be revoked if either of the two houses or both houses reject president's rule by simple majority. If the Supreme Court or the High Court declares the imposition of president's rule as unconstitutional, invalid, then president's rule is revoked. And what happens because of this president's rule? There is no impact on fundamental rights. Fundamental rights are not impacted. They are not affected because of president's rule. There is an impact on fundamental rights because of national emergency, but not because of president's rule. In president's rule, what happens? Powers of state executive are given to union executive. Powers of the state legislature are given to union legislature. That means if West Bengal is under president's rule, for West Bengal, they don't share federal relationship with the center. That means there is no dual government, there is no distribution of powers. That means center now runs the state, central executive, union executive runs the state, and central legislature, which is the parliament, makes laws for that state. That is the impact of president's rule, which means during president's rule, our constitution for that state is converted from a federal polity into a unitary polity. But something happened. What happened? 1977, when Janata Party came to power, Janata Party saw that there are various Congress governments in various states, particularly in North India. What Janata Party cabinet did? Advised the president, please dismiss all these Congress governments. Let's impose president's rule. Once president's rule is imposed, we will have fresh elections in all these states. What was the logic? The logic was, if the Congress party has lost the 1977 elections, in the entire North India, they could win only 2 Lok Sabha seats. That means in the entire North India, people are not in favor of the Congress. Why should these governments continue? President was advised by the cabinet, dissolve and dismiss these governments, impose president's rule. 1980, Indira Gandhi came back to power. Advised the president, please dismiss all these non-Congress governments in the states, because now since I have won the election, which means people's support is with Congress, what are these non-Congress governments doing? Dismiss all of them, impose president's rule. Something strange happened in the 1990s. First in Karnataka, then in Madhya Pradesh, then in Nagaland as well, Mizoram as well, and various other states. What happened in Karnataka? S.R. Bommai was the chief minister. He was from the Janata Party. I have given you that example, but now let me clarify it more. S.R. Bommai was the chief minister. He was from the Janata Party. But there were independents and other smaller political parties also supporting S.R. Bommai's government. Because he did not have the majority of his own, he needed support of independents and smaller political parties to cobble up a coalition so that this coalition government has simple majority on the floor of the Legislative Assembly. Because that is what parliamentary democracy is. Council of Ministers and the Chief Minister, they are responsible to Lok Sabha. They remain in office till their time they have the confidence in the Legislative Assembly. A letter was sent to the governor by 12 MLAs saying we have withdrawn support to S.R. Bommai. Which means now the government is in a minority. If this letter is true, the government is in the minority. That means they don't have the support. They don't have the majority in the Legislative Assembly. S.R. Bommai rushes to the Raj Bhavan, where we have the governor. And he's telling the governor, I have the majority. In fact, the letter that you have got, 9 of these MLAs are saying they have not written that letter. So my government is not in the minority. I have the majority. And if you want, I can convince, I can prove majority on the floor of the Legislative Assembly, on the floor of the Karnataka Legislative Assembly. Governor says, no, you are dismissed. And what governor does? Submits a report to the president that there is a breakdown of constitutional machinery in Karnataka. Why? Because there are these 12 MLAs who have withdrawn support to S.R. Bommai government, and this has resulted in breakdown of constitutional machinery. Because what is breakdown of constitutional machinery? Constitution says there shall be chief minister and council of ministers who will advise the governor. But now we don't have a chief minister and the council of ministers. Why? Because they don't have the majority on the floor of the Legislative Assembly, which means there is breakdown of constitutional machinery. S.R. Bommai told the governor that give me the opportunity, I will prove the majority on the floor of the Legislative Assembly. Governor says, no, you are dismissed. I have sent a report to the governor. I have sent a report to the president. President, on the advice of the cabinet, has approved president's rule. S.R. Bommai, you are dismissed. And S.R. Bommai approached the Supreme Court. And this case came to be known as S.R. Bommai versus Union of India, 1994. If Keshavananda Bharati judgment has saved India's democracy, if 44th Constitutional Amendment Act 1978 has prevented the misuse and abuse of Article 352, it is this S.R. Bommai judgment of 1994 which has prevented the misuse, overuse, hyperuse, abuse of Article 356. Now a constitution bench of the Supreme Court has to decide, how do we prevent the misuse of Article 356? Is the dismissal of S.R. Bommai correct or incorrect? Constitutional, unconstitutional, legal or illegal? Something happened in Madhya Pradesh as well. December 1992. Babri Masjid is demolished. When Babri Masjid is demolished, there are riots in different parts of the country. Madhya Pradesh, Maharashtra, Rajasthan and others. In Madhya Pradesh, the government failed to control the riots. There were riots between Hindus and Muslims. The government of Madhya Pradesh has failed to control these riots. When these riots have been failed, the control of these riots is not possible. The governor submitted a report that in my state there is breakdown of constitutional machinery. This report is sent to the president. President says, why are you sending it to me? I will send it to the cabinet because I can't take independent decision. Cabinet advised the president that since there are riots between two communities, dismiss the state government, impose president's rule. And in Madhya Pradesh, the government was dismissed, president's rule was imposed. Madhya Pradesh chief minister also approached the court. Supreme Court said, you are raising the same issue as SR Bammai is raising. I will club the two matters together. This case came to be known as SR Bammai versus Union of India. Nagaland also approached, Mizoram also approached, and this case came to be a landmark case where there are state governments who are trying to protect their identity, who are trying to protect the federal setup of this polity, and they are fighting a case against Union of India, SR Bammai versus Union of India. In this judgment, Supreme Court said, federalism is part of the basic structure of the Constitution. This concept of dual government distribution of powers between the center and the state, this concept is part of the basic structure of the Constitution. Through Article 356, when you dismiss a state government, when Parliament assumes the power to make a law for that state, this should not be done to destroy federalism. This should be the last resort. When nothing changes, situation deteriorates, then you can impose president's rule. Otherwise, no, because then you will be disturbing federalism. Because there is a thin line which you cannot cross. If you cross that line, you're converting our federal polity into a unitary polity. The Supreme Court said, number 2, Legislative Assembly shall not be dissolved unless both houses of the Parliament approve president's rule. For example, this is your house. The government says that this house has been illegally constructed. We have to demolish it. Whether this is illegal or not, that is for the court to decide. If the court says, yes, this is illegal, then the government can destroy it, demolish it. But what if the government demolishes this house and you approach the court? Now the court will say this house should not have been demolished, but it has already been demolished. That means now I have to construct the house again. Right or wrong? When president's rule was imposed by the president, what was the logic? Why we say it was misused? Because when in 1977, elections were held and Janata Party won the majority of the seats, they thought that if elections are held in these states as well, when Legislative Assembly elections is held in these states, there the people are against the Congress. So if election is conducted, we will win. Janata Party will win. So what they did, they imposed president's rule. Even without waiting for the parliamentary approval, the Legislative Assembly was dissolved. When Legislative Assembly is dissolved, now there is no other option but to organize elections. So when elections will be organized, Janata Party will sweep that election. Same was done by Indira Gandhi. If in 1980 I have won the election, what are these non-Congress governments doing? Because in these states, I have won the majority of seats in Lok Sabha. But my government, my political party is not in power in these states because Legislative Assembly elections was held previously. Advise the president, dismiss the Chief Minister, Council of Ministers, impose president's rule and dissolve Legislative Assembly. When Legislative Assembly is dissolved, what is the only option? hold fresh elections, and in these fresh elections, I will win. The Supreme Court said you can't do that. Can't do that unless and until both houses of the parliament approve president's rule. Only after that you can dissolve the legislative assembly. And if you do it now, without getting approval of both houses of the parliament, we have the power to revive back that dissolved legislative assembly. That's the power of judicial review. Do not dissolve legislative assembly unless and until both houses of the parliament approve president's rule. That's point number 2. How this Article 356 misuse can be prevented and was prevented by SR Bombay judgment. And Supreme Court said number 3, judicial review. Every action of president's rule, we will review and we will see whether it was done rightly or wrongly. If it was done wrongly, we will revoke president's rule. If it was done rightly, then you're right. When judiciary said this, that judicial review will happen for every action of president's rule, the Attorney General was smiling. The court asked, why are you smiling? Attorney General said, my lord, you cannot do judicial review here. Said, why? Why can't we do that? Because there is a limitation. Said, what is the limitation? My lord, look at Article 74, Clause 2. What is Article 74, Clause 2? Sir, Article 74 says, there shall be Council of Ministers with Prime Minister at its head to aid and advise the President, who shall act on that advice. But Article 74, Clause 2 says, this advice shall not be inquired into any court of law. This advice that cabinet gives the president, what is this advice? You cannot inquire into any court of law. That is a limitation under Article 74, Clause 2. So when you say judicial review will happen, do you know what is the process? Governor submits a report to the president. President refers this report to the cabinet. Cabinet meeting takes place. They discuss this report. And then the cabinet is advising the president that on these grounds, you should proclaim president's rule under Article 356. If you say judicial review would happen, that means you will have to review what advice was given by Council of Ministers to the president. That you can't do because there is a limitation under Article 74, Clause 2. The advice tendered by Council of Ministers to the president shall not be inquired into any court of law. But Supreme Court said, you're right. So what do? We will not get into this advice. We will not ask you share this advice with us. Attorney General said, sir, sometimes even the governor's report is not required. Even without the report of the governor, the president can proclaim president's rule. If the president is satisfied on the basis of the report or even otherwise that there is breakdown of constitutional machinery, sometimes there is no governor's report as well. And whatever advice we give the president, you cannot inquire into that because that is a limitation under Article 74, Clause 2. Supreme Court said, you're right. Don't show us the advice, what you gave the president. We don't need to look into that. But there should be some material document on the basis of which you gave that advice to the president. Sir, what are you saying? You can't give advice to the president out of thin air. There has to be some document. There has to be some material. There has to be some proof on the basis of which you claim that there is breakdown of constitutional machinery. And that is when you advise the president, please impose president's rule. Show us that material document. Show us that material document on the basis of which you gave the advice to the president to proclaim president's rule. Give us that material so that we can satisfy ourselves whether this was done rightly or wrongly. That is judicial review. And this was brilliantly employed by the Supreme Court in the Arunachal Pradesh case, 2016. Arunachal Pradesh was a beautiful example. 2014 elections were held, Lok Sabha elections were held, BJP emerged as the winner and formed the government at the center. In Arunachal Pradesh, it was Congress which emerged as the winner. But the central government will not tolerate a political party from the opposition to form the government in a state. One by one, some members of the Congress are now moving to the BJP. Chief Minister is there, and the cousin of the Chief Minister is also the Speaker. Both belong to the Congress. These rebel MLAs who rebelled against the Congress, they were now supported by the BJP, and they wanted to remove the Speaker. When they wanted to remove the Speaker, Speaker is not calling the session. Speaker is not organizing the session. And when they had to remove him, instead they met at a hotel. And they said this hotel is the Legislative Assembly. And in that hotel, they passed a resolution removing the Speaker. How's that possible? The legislature of a state will meet at such location as the governor decides. When these rebel MLAs supported by the BJP, when they went to attend Legislative Assembly was closed. Who will summon Legislative Assembly? Governor. Governor and BJP, they're close to each other because governor is appointed by the BJP. This governor said, let's meet at a hotel. This hotel will be converted into a Legislative Assembly. These rebel MLAs, supported by the BJP, they met at this hotel, passed a resolution removing the Speaker. Said, even this is not helping. Governor submitted a report to the president, dismissed the state government because there is breakdown of constitutional machinery. The cabinet advised the president, please impose president's rule, proclaim president's rule under Article 356. The government is dismissed. The government, the chief minister approached the Supreme Court. Supreme Court said there is judicial review. Government, show us the advice. Sir, you can't inquire into that advice because the advice tendered by Council of Ministers to the president cannot be inquired into any court of law. Sir, that I know, but show me the governor's report. Because it is on the basis of the governor's report that you gave advice to the president. Show me the governor's report. And in that governor's report, it was mentioned that these are the reasons why there is breakdown of constitutional machinery. One such reason was Mithun was slaughtered. Not Mithun Chakraborty. Mithun is a state animal in Arunachal Pradesh, like a buffalo. Mithun was slaughtered outside the Legislative Assembly of Arunachal Pradesh. This is one reason why there is breakdown of constitutional machinery. Supreme Court said, what rubbish? An animal is slaughtered outside the legislature and you say this is breakdown of constitutional machinery? No. President's rule is wrongly imposed in Arunachal Pradesh. The chief minister who was dismissed, you are again the chief minister. Supreme Court said in S.R. Bommai case that there is a difference between breakdown of law and order and breakdown of constitutional machinery. If the president is satisfied on the report of the governor or even otherwise that there is a breakdown of constitutional machinery, only if there is a breakdown of constitutional machinery, president's rule can be imposed. But what is this breakdown of constitutional machinery? The definition is not given in the constitution. It's a matter of interpretation, subjective interpretation. Supreme Court said in SR Bommai there is a difference between breakdown of law and order and breakdown of constitutional machinery. Only if there is a breakdown of constitutional machinery can you proclaim president's rule. Otherwise, no. So there are some fit cases where you can impose president's rule, but there are some unfit cases as well where you can't impose and proclaim president's rule. Supreme Court was asked, what are these fit cases? Supreme Court said, number one, elections have happened. No political party is in a position to form the government. For example, Maharashtra. When no political party is in a position to form the government, the governor is inviting leaders, please come and form the government. Nobody is forming the government because nobody has the majority. This is breakdown of constitutional machinery. Sir, how? Because constitution says there shall be council of ministers with chief minister at its head. So it is necessary to have the chief minister and council of ministers. When we can't have a chief minister, we can't have a council of ministers. This is breakdown of constitutional machinery. And in that case, it is necessary for you to proclaim president's rule because we have to run the state. Without the government, how can you run the state? For that, president's rule is a fit case. This is a fit case of president's rule. In case there is hung assembly, in case there is withdrawal of support, BJP, PDP came together to form the government in Jammu and Kashmir. After a couple of years, BJP withdrew support to the PDP government. When you withdrew support to the PDP government and no other political party is coming forward to form the government, this is a fit case of president's rule because there is breakdown of constitutional machinery. Third, governor has to order floor test. Governor cannot assume loss of majority. Karnataka governor, come here. What are you doing? Sir, there is breakdown of constitutional machinery because the SR Bommai, he lost majority. Who are you to assume loss of majority? Council of Ministers and the Chief Minister, they are accountable to Legislative Assembly. Whether they have the majority or not, you can't assume. Order a floor test. Ask the Chief Minister to introduce a confidence motion inside Legislative Assembly. And on the floor of the Legislative Assembly, if he is or she is able to form the government, if she is able to get the majority, confidence of the legislature, who are you to assume that he has lost the confidence? You're wrong. SR Bommai was wrongly dismissed. President's rule was wrongly imposed in Karnataka. Suddenly, Madhya Pradesh government, former chief minister is happy. Sir, me too. My government was also wrongly dismissed. Same case, sir. SR Bommai case. Same, exact, ditto. Come here. What happened in your state? Sir, breakdown of law and order. There were riots between Hindus and Muslims after the demolition of Babri Masjid. There were riots. We could not control it. That is my problem, yes, but it's a breakdown of law and order. You're saying there is a difference between breakdown of law and order, breakdown of constitutional machinery. In my state, there was breakdown of law and order. Please restore me as well. Sir, no, in your case, you were rightly dismissed. Sir, why? Because secularism is part of the basic structure of the Constitution. And if secularism is violated in a state, that is not the breakdown of law and order. That's the breakdown of constitutional machinery. You were rightly dismissed. Go. Then, sir, what are these unfit cases of president's rule? Corruption allegations against ministers. It used to happen prior to SR Bombay judgment. There are 20 ministers in the state government. Corruption allegations against a minister or two ministers. Governor will submit a report. Governor's report said breakdown of constitutional machinery. Why? Corruption allegations against the minister. Really? Government dismissed. This is not breakdown of constitutional machinery. Mere corruption allegations against a minister, or even if they are involved, you can dismiss a minister, but you can't dismiss the entire government. You are taking federalism for a toss. This is not the fit case. This is an unfit case of President's rule. Sir, what are the other unfit cases? Loss in elections to Lok Sabha cannot justify the dismissal of state government of that party. That used to happen. Congress lost the Lok Sabha elections. Janata Party said, then if you have lost the Lok Sabha election, then why are your state governments functioning? Dismiss them because you have lost the majority, you have lost the confidence of the people. Supreme Court said people may vote differently in a Lok Sabha election and in a Legislative Assembly election. That does not mean that just because your party lost the Lok Sabha election, your party, your government in the state cannot continue. That is not true. This is an unfit case of President's rule. Government failing to implement election manifesto. Previously, it used to happen that a political party is promising sun, stars, and the moon to the people. The ruling party at the center is unable to match that offer. This political party wins the election. But now the central government is waiting. You promise them sun, moon, and the stars, give them. Not able to give, breakdown of constitutional machinery. Government is dismissed. Why? Because there is breakdown of constitutional machinery. This government has failed to meet its election manifesto, the promises that it made to the people in its election manifesto. Court said, no, this is not the fit case of President's rule. Please understand the difference. There is a difference between breakdown of law and order and the breakdown of constitutional machinery. If you mix the two, you are destroying federalism. If there is breakdown of law and order just because a political party has not abided by its election manifesto, just because there is a corruption allegation against a minister, that is not the fit case of President's rule. That's a breakdown of law and order, not the breakdown of constitutional machinery. And it is thanks to this SR Bombay judgment that we have seen less instances of the abuse of Article 356. That is why after this judgment, there have been only few cases of improper use of Article 356. And even in those cases, the courts came to the rescue. Court came to the rescue in Arunachal Pradesh. Court came to the rescue in Uttarakhand as well, where the governments in both these states were restored because the court said Article 356 was misused. That is Article 356 of the Constitution. Court further said that there is something called Article 365 of the Constitution. What is Article 365? Under which directives by the center are sent to the states. And the sanction behind these directives is coercive. What are these directives? 4 important directives. Number 1, in my state, there are linguistic minorities. For example, I am from Karnataka, and in my state, there are linguistic minorities from, let's say, Maharashtra. It is the duty on the state to provide educational opportunities to the children of these linguistic minorities till their primary stage of education, at least till the 5th standard. I am not taking any steps to provide them education in their mother tongue. I'm not doing anything. If under Article 365, a directive is issued by the center to me that you have to provide educational opportunities to the children of the linguistic minorities till the primary stage of education, and I do not abide by this directive, I violate this directive, then under Article 356, President's rule can be imposed. Under Article 365, directives are issued, and these directives are binding on the state. If the state does not abide by these directives, then Article 356 can be used, state government can be dismissed, President's rule is imposed. Directive: in my state, there are scheduled castes and scheduled tribes. For such communities, there are various schemes launched by the central government. If I, as the state government, do not implement these central schemes, which are meant for the scheduled castes and scheduled tribes, what will happen? The central government will issue a directive to me under Article 365. Please abide by this directive. Please implement the schemes, the central schemes that we have tailor-made for SCs and STs. If I do not abide by that directive, then Article 356 can be used to dismiss me. In my state, there are means of national importance. There are roads, highways, national highways, for example, the railways, for example. What if there is a protest, massive protest? People are demanding a reservation. People are demanding something else. And these protests, they have blocked the highway. They have blocked the railway as well. Railways come under center. Highways come under center as well. It is through these highways that people can move from one state to another. Fraternity is developed through this, when you are freely moving from one state to another. But what if the protesters have blocked railway lines, blocked the national highways? The central government can issue a directive under Article 365. Please ensure that highways and railways are not blocked. The chief minister has to go begging before the protesters. Please protest at my bungalow. Protest somewhere else, but don't block railways, don't block national highways, because my government is at stake. Because if I do not abide by this directive, because these are means of national importance, railways, national highways, if you don't go out, if you keep blocking this, my government will be dismissed. If I fail to abide by this directive, then Article 356 can be used, my government can be dismissed. So the court said that these directives are binding. Yes. In these 4 instances, these directives are binding. If you disrupt post and telegraph, if you disrupt national highways and railways, if you do not implement schemes meant for SCs and STs, if you do not abide by the directive as providing educational opportunities to the children of linguistic minorities till their 5th standard, if you fail to abide by these directives, because the sanction is coercive, I can coerce you into accepting this. You have to abide. If you don't abide, then under Article 356, the state government can be dismissed, President's rule can be imposed. This is also the fit case of President's rule. And what is happening in Manipur right now is also a fit case of President's rule. But sir, in Manipur, there is breakdown of law and order. There are Métis and Cookies who are at each other's throats. They're killing each other, so it's a breakdown of law and order. How is this breakdown of constitutional machinery? It is. Because there are some areas in Manipur where the state is absent. What do we mean by the state is absent? There are areas where the writ of the state does not extend. So what does that mean? There are areas where the state cannot send its police to these areas because they are controlled by the cookies, which means the state government is missing. State government is absent. It's failing to control the problems because of two tribes. So it's not a normal law and order problem. It's the breakdown of constitutional machinery because the executive power of the state has to extend throughout that state. But there are some areas which are liberated now. There are some areas where the state government is absent, where state police cannot enter, where the government cannot perform its duty. This is breakdown of constitutional machinery, and this is the fit case of president's rule. But sir, then why is president's rule not imposed? Ask the government. Since Mr. N. Biren Singh, who is from the BJP, is the chief minister of Manipur, if it was from the Congress, by now the government would have been dismissed a year ago. But since the ruling party at the center and the state are the same, that is why we can say president's rule was not imposed, despite the fact that this is a fit case of president's rule. If it was from the opposition, by now it would have been dismissed. That is Article 356. Sir, why didn't Supreme Court impose president's rule? How can Supreme Court impose president's rule? That's not the power of the Supreme Court. Power of the Supreme Court is review the imposition of president's rule. It cannot impose president's rule. Sir, what if a state makes a religion state religion and there are no protests, no riots? You can't make a religion as the state religion because that would violate secularism. Can president issue multiple proclamation of emergency? Yes. The president can impose national emergency on the grounds of war. Then the president can issue let's say firstly the president proclaimed national emergency on armed rebellion because there was some problem internally. But now there is war as well. President will issue proclamation on the grounds of war. Sir, what difference will it make? The difference would be that in armed rebellion, Article 19 is not automatically suspended. And in emergency on the grounds of war, Article 19 is automatically suspended. So president can, through a subsequent proclamation, change the grounds on the basis of which emergency was proclaimed. Sir, why didn't Supreme Court impose president's rule under Article 142? What is that 142? We will discuss in judiciary, but it would be wrong on part of the judiciary to get involved in this matter. In fact, Andhra Pradesh High Court was heavily criticized by the people, by the experts, by the Supreme Court itself for getting involved in this matter. What is this matter? Mr. Jagan Mohan Reddy is the Chief Minister of Andhra Pradesh. There is allegation of corruption against him, allegation of corruptions against his ministers as well. Matter went to the Andhra Pradesh High Court. Andhra Pradesh High Court said, we will see if we can recommend imposition of president's rule in Andhra Pradesh. It did not say we recommend imposition of president's rule. It only said we will see whether we can recommend imposition of the president's rule. And everybody criticized this, saying, how can judiciary get involved in this matter? And where does judiciary derive its power? How can judiciary recommend president's rule? One explanation given to this was the text of Article 356 itself. If the president is satisfied on the report of the governor, or even otherwise would mean maybe on the advice of the judiciary, but that would violate separation of powers. That is why this order was recalled by the Supreme Court. Supreme Court criticized the High Court of Andhra Pradesh for getting involved in this matter, saying you don't have that power, you don't have that jurisdiction. That is why courts should not get involved in imposing president's rule, but it should always get involved in deciding, reviewing whether it was done rightly or not. Can Parliament issue an ordinance to declare war? To declare war, you don't need to pass any law. President will just have to issue an order, notification on the advice of the Prime Minister and Cabinet declaring war on a country. For that, there is no law required. Sir, in Manipur issue, Centre made a commission which recommended ST status to Métis, but state failed to do. Then High Court also ordered do the same. Then why state government was not dismissed? That, my dear, you have to ask the centre. Why did you not dismiss the state government? Okay. Now we have financial emergency under Article 360 of the Constitution. What does Article 360 say? It empowers the president. That what president you can do? You can proclaim financial emergency. When? If the financial stability or the credit is under threat. If financial emergency is imposed today, by the president on the advice of the cabinet, because there is no discretionary power of the president. If financial emergency is proclaimed today by the president, then within 60 days, that means within 2 months, both houses of the parliament shall approve financial emergency by simple majority. Once approved, financial emergency continues unless revoked by president. Financial emergency is proclaimed by the president on the advice of the cabinet. Once it is proclaimed, then within 2 months of its proclamation, both Lok Sabha and Rajya Sabha will have to pass a resolution by simple majority approving financial emergency. Once it is approved, it continues forever and ever and ever unless and until revoked by the president on the advice of the cabinet. Which means national emergency, if it is proclaimed today, then within 1 month, within 30 days, both Lok Sabha as well as Rajya Sabha will have to approve national emergency by special majority. Once it is approved, it continues for 6 months. Can be extended for 6 months, extended again for 6 months, for 6 months, for 6 months, for 6 months. There is no upper limit. President's rule, once it is imposed today, within 60 days, by simple majority, both houses of the parliament have to approve president's rule. and it continues for 6 months, then for another 6 months. Then if two conditions are satisfied, for 2 more years. That means maximum validity is 3 years. But financial emergency, once it is proclaimed today, both houses of the parliament, once they approve this financial emergency by simple majority, then it continues unless and until it is revoked by the president, which means there is no upper limit. Until date, financial emergency has never been imposed. And hopefully, it should never be imposed in India ever. Because it can be imposed only when the financial system or the stability or the credit of India is under threat. Maybe we have no money to pay salaries, maybe we have no money to buy crude oil, maybe we have no money to provide subsidies to the people. When the financial stability or the credit, the money supply in this country is under threatened, then president can proclaim financial emergency. What happens during financial emergency? The executive authority of the union shall extend to the giving of directions to any state to observe canons of financial propriety. What is that canons of financial propriety? For example, in 2008, there was the global economic crisis because of the fall of the Lehman Brothers in US, because of AIG crisis. So much. There was a lot of crisis in 2008, which you would discuss obviously in your economics lectures. Basis that, some directives were issued by the central government to its own ministers, not to the states because there is no financial emergency, to its own members. Ministers were told you should not be now staying at the 5-star hotels. You should now travel in the economy class and not travel in the business class or the first class. One journalist, Kanchan Gupta, tweeted Shashi Tharoor, who was then the minister, "Tell us, minister, next time you travel to Kerala, will it be a cattle class?" Cattle class was the derogatory term used for economy class. Kanchan Gupta said, "Absolute." Mr. Shashi Tharoor replied, "Absolutely, in cattle class, out of solidarity with all the holy cows." Shashi Tharoor had to resign basis this tweet. But that is not our intention to discuss. What is to be discussed is, number one, financial emergency has never been imposed. Not even in 1991, when there was BOP crisis because of Gulf War. Because of the Gulf War, because of the rising crude oil prices, because we import crude oil, it had a strain on our payments. There was a BOP crisis. Some reports say we didn't have forex, foreign reserves, which could last even for a day. Some said it could have lasted for 3 days. Some said it could have lasted for a week. Ultimately, gold was transported, and for that gold, we got the loan. And later on, we reached the IMF, International Monetary Fund, and then IMF put some conditions which led to the liberalization, privatization, reforms. And basis those conditions, money was given to us. So even at the peak of the balance of payment crisis in 1991, emergency was not imposed. Financial emergency was not imposed, despite the fact that it was our financial stability and credit was threatened. It was not imposed in 2008 because of the global economic crisis. But what can happen during financial emergency? Central government will issue directives to all the states that you observe propriety. Don't be extravagant in your spending. Don't stay in 5-star hotels. This directive can be sent to all the ministers. Travel economy class, or don't travel at all unless and until it is absolutely necessary. All your money bills, all your budget should be reserved for the consideration of the president. Because all the money that is available with the states should be kept at the disposal of the center, so that center can take us out of this economic turmoil. During financial emergency, salaries can also be reduced. When we will discuss various constitutional offices, for example, judges, president, CAG. One condition, or CEC, one condition is that once appointed, their salaries cannot be varied to their disadvantage. I was appointed by Byju's. I was told you will be given 100 rupee as your salary. Because of that 100 rupee, I joined Byju's. After 2 months, Byju's is saying, no, we will give you 10 rupees. That means you are varying my salary to my disadvantage. Once the president was appointed, once the judge was appointed, their salary was given. The salary was fixed. Midway, you cannot say that now your salary has been reduced, because that basically means you're trying to exert influence on me. Give us this verdict, otherwise your salary will be reduced. Give us a good audit, otherwise your salary will be reduced. But your salaries can be reduced only during financial emergency. So the salaries of these important constitutional functionaries cannot be varied to their disadvantage except during financial emergency. All money bills or bills which deal with withdrawal of money from consolidated fund of the state, they can be reserved for the consideration of the president. It shall be competent for the president during any period, any proclamation issued under this article, reduction of salaries for all the employees of the union, including judges of the Supreme Court and High Court. So long story short, what happens during financial emergency? During financial emergency, salaries of government employees, important constitutional functionaries can be reduced. During financial emergency, the center will ask all the states that whenever you pass a money bill, the governor should reserve that for the consideration of the president. The center will issue directives to the state that don't spend extravagantly, lavishly, be considerate in your spending, control down your expenses, observe the canons of financial propriety. That's what we call austerity measures. These austerity measures should be practiced and followed. That is financial emergency. And that completes our discussion on emergency provisions. Sir, is this true that during financial emergency, salaries of the judges are not deducted? Salaries, including the judges of the Supreme Court and High Court, they can be reduced. Sir, is there reapproval required for prolongation of financial emergency? No. Once financial emergency is imposed, it is approved by both houses by simple majority within 60 days. It continues unless revoked by the president. Are all fundamental rights withdrawn during national emergency? No fundamental right is withdrawn. Only the operation of some fundamental rights is suspended, except Article 20 and 21. President, vice president can also be removed. Yes. Sir, is it correct time to remove the ruling party next year for violation of the constitution? Now, that is the job of the people. That's the decision of the people, whether they want or they don't want. If they believe that the government has done well, they should re-elect the government. If they believe that the government is not doing well, it's the people's power ultimately. The sovereignty lies with the people. Can national emergency be imposed in particular part of the country? Yes. What is the impact of financial emergency on common people? Maybe the welfare schemes can be stopped because the government does not have the money. How many times president's rule has been imposed in Uttar Pradesh? Should be more than 8 times, but I don't remember the exact number. There is no joint sitting if the emergencies are not approved. They have to, both houses have to approve emergency separately. Can president remove central government for breakdown of constitution? No, there is no such thing. The money deposited in banks will also be confiscated during financial emergency? No. How many times national emergency has been imposed? 3 times. Why financial emergency has not been imposed? Because we never felt the need. Ritika, what's your question? Construction of a Hindu temple in an election manifesto is against the constitution, right? Election manifesto, it's not a legal document after all. No action can be taken against you. I was asking financial emergency only, how many times has it been imposed? It has never been imposed. Can financial emergency and national emergency be at the same time? Yes, can be. Has someone not filed petition against president's rule not imposed in Manipur? No. Is Article 35A mentioned in the Constitution? It was. Now it has disappeared. What is the correct meaning of election manifesto? The promise of a political party to its people that after they will come to power, if people vote for them, these are the things that we will implement. It's a BBC documentary which is against the Prime Minister. Isn't this breakdown of constitutional machinery? No, why? That documentary was made, that was banned in India. That's it. How is that breakdown of constitutional machinery? Okay. Now let's look at schedules. And we have discussed in Article 1, schedules are explanatory memorandum of an article. If an article requires more explanation, instead of adding the explanation in the article itself, which would make that article bulky, we add the explanation towards the end of the Constitution by adding a schedule. Clear? Initially, which means in 1950, when the Constitution was enacted, we had 8 schedules. Now, we have 12 schedules. You may also be asked in your prelims examination when these schedules were added. For example, the question that we discussed on Friday. 9th schedule was added during the prime ministership of. Such questions have been asked. 9th schedule, 10th, 11th, 12th. 9th schedule was added in 1951. First Constitutional Amendment Act. 10th schedule was added in 1985. 52nd Constitutional Amendment Act. 11th and 12th schedule. 11th schedule, 73rd. 12th schedule, 74th Constitutional Amendment Act, 1992-93. Let's discuss all these schedules except schedule 11 and 12, which we will discuss in local government, where we will talk about Panchayati Raj institutions and municipalities, which are part of the local government, we will discuss 11th and 12th schedule. Till then, we will discuss all these 10 schedules. Schedule 1 we have discussed previously. It contains names of the states and union territories. So all the 28 states, all the 8 union territories, their names, their details are mentioned where? First schedule of the constitution. Schedule 2 talks about the salaries of the president and the governors. Once the president's salary is determined by the parliament, president's salary is 5 lakh rupees per month. Where is it mentioned? It's mentioned in the schedule 2nd of the constitution. Similarly, the salary of the governor, salary of the speaker, deputy chairperson, judges of the Supreme Court and High Courts, the comptroller and auditor general. So in match the following typed questions, this information is important for you. So on one side, you may be provided with the schedules. On the other side, other column, you will be provided with the explanation. Then you have to match. So you should know Schedule 1 deals with the names of the states and union territories. Schedule 2 talks about the salaries and emoluments of president, vice president, speaker, judges, CAG. Schedule 3 talks about oath or affirmation. What is the difference between oath and affirmation? Oath is for believers. I swear in the name of God that I will bear true faith and allegiance to the Constitution as per the law established, that I will faithfully discharge the duties of my office. Affirmation is for a non-believer. I solemnly affirm that I will abide by the Constitution, respect its ideals. The oath and affirmation of president, the vice president, is not mentioned in third schedule. It's mentioned in the text of the Constitution itself. But when you are contesting elections, as a candidate contesting the election, you have to subscribe to an oath. Where is that oath mentioned? Schedule 3. As the judge of the Supreme Court, when you are to be appointed, you have to subscribe to an oath. Where is that oath mentioned? Schedule 3. As the minister, as the CAG, all these other important functionaries who have to subscribe to an oath other than the president and the vice president, their oath or affirmation is mentioned where? Schedule 3 of the Constitution. And Schedule 4, for example, the oath is like this. If you take an oath of a cabinet minister, for example, the Prime Minister takes this oath. Mr. Amit Shah has taken this oath. Mr. S. J. Shankar has taken this oath. I, S. J. Shankar, do swear in the name of God, or I, S. J. Shankar, solemnly affirm that I will bear true faith and allegiance to the Constitution as by the law established, that I will uphold the sovereignty and integrity of India, that I will faithfully discharge the duties of the office about which I am to enter. Then there is an oath of office, then there is oath of secrecy as well. That means first as a minister, I take the oath of office. Then I take the oath of secrecy. That means as the minister, I will be privy to a lot of information. I will have access to a lot of information. I will keep this information secret. I will not reveal it to someone. I will reveal it to the Prime Minister. I will reveal it to others who are required to know, but not to my family members, not to others. That I will not directly or indirectly communicate or reveal to any person or persons any matter which shall be brought under my consideration or shall become known to me as a minister for the Union, except as may be required for the due discharge of my duties as such minister. I will have to reveal it to my colleagues that we have to take this decision, to my secretaries, because we have to take a decision. I have to run that ministry because that information will come to me. For example, I know what is the cost of every Rafale jet if I am Mr. Rajnath Singh. What are the features of the Rafale jet? These features I don't have to reveal to somebody, because if Pakistan comes to know about that or our enemies come to know about that, they will launch an attack like that, keeping the specifications of our military helicopters or Rafale jets in mind. But I have to tell it to my colleagues. I have to tell it to the Prime Minister. I have to tell it to my secretaries. I have to tell it to the army that this is the Rafale jet that we have, to our Air Force, that this is the specification that we have. Schedule 3 of the Constitution. Schedule 4 talks about allocation of seats in the Council of States. And Council of States is Rajya Sabha. For example, from UP, we will have 31 MPs in Rajya Sabha, mentioned in Schedule 4. From Maharashtra, we will have 19. From Tamil Nadu, we will have 18. From Andhra, we will have 11. From Telangana, we will have 7. All these seats are mentioned where? In Schedule 4 of the Constitution. And tomorrow, when we meet at 6 o'clock in the morning, we will discuss Schedule 5, which deals with the administration of tribal areas other than Assam, Meghalaya, Mizoram, and Tripura. Then we will discuss Schedule 6, then Schedule 7, then Schedule 8, then Schedule 9, then Schedule 10. And once that is over, then we will look at center-state relations tomorrow. So see you tomorrow, 6 o'clock in the morning. Sir, in case of central government, if there is no majority of any party, then president has the discretion to appoint prime minister. But why in state legislature, if there is no majority of any party and no coalition party is ready to form the government, then why president's rule is imposed on this basis? Is it not unfair? No, it's not unfair because the state has to run. At the center, we have the president to run the state, to run the government, along with the prime minister, because we need a prime minister. Even if the prime minister has lost the majority, we will ask him to continue as the caretaker prime minister. But at the state, if chief minister is not possible, the government is not possible, we have to have a mechanism where we can administer that state. And that state is run by the president, just like the center is run by the president. Satish, what's your question? Is Article 32 suspended during national emergency? Article 32 you're using to approach the court when your fundamental rights are violated. If your Article 14, 15, 16, 17, 18, 19, 22, 23, 25, 26, 27, 28, 29 is violated, you cannot use Article 32 to approach the court. Why? Because their enforcement is suspended. But if your Article 21 and 20 is violated, you can use Article 32 to approach the court. Because during the emergency, Article 20 and 21 are not suspended. Vishal, is it necessary to impose president's rule? Now, this is a vague question. Necessary to impose where? That should be the question. You tell me the scenario, I'll tell you is it necessary or not. Sir, how can the salaries of President VP could be changed? Is it via Constitutional Amendment Act? No. A law is passed by the parliament. It's an ordinary law passed by simple majority. The salary can be changed. Atharv, I have completed the class. I'm not teaching anything new. But if you have questions, you tell me. I'm here. Sir, what if suddenly we need emergency and we don't have Lok Sabha? Then can Rajya Sabha impose national emergency? Gunjan, Rajya Sabha can never impose national emergency. Lok Sabha can never impose national emergency. When did I say that? I said President proclaims national emergency on the advice of the cabinet. Now your question is, who will approve it if we don't have Lok Sabha? Rajya Sabha will approve it within 30 days. Rajya Sabha will approve. Then when Lok Sabha is convened, then that Lok Sabha will have to also approve within 30 days. Sir, since MP of Rajya Sabha has tenure of 6 years, then what if Prime Minister is a member of Rajya Sabha? Why his tenure will be 5 years? His tenure as Prime Minister would be 5 years, but his tenure as an MP of Rajya Sabha would be 6 years. So you tell me, when Dr. Manmohan Singh lost power, Mr. Modi came to power, Was Dr. Manmohan Singh not continuing as the member of the Rajya Sabha? He was. You are Prime Minister not because you are a member of Parliament. You are Prime Minister because you have the majority in Lok Sabha. Sir, what topics are left now? Schedules, the remaining schedules. Then we have center-state relations. Then we have Panchayati Raj institutions and municipalities. Then we have judiciary. Then we have elections. And then we have the wrap-up of the entire constitution that we have discussed. Constitutional bodies. We have discussed 3 constitutional bodies: National Commission for SCs, STs, National Commission for the backward classes. Now, as and when we approach further, we will encounter Election Commission of India. That is also a constitutional body we will discuss. But sir, salaries and emoluments are mentioned in Schedule 2, then it requires constitutional amendment. If you have to bifurcate a state, you have to amend Schedule 1 and Schedule 4, but that is not a constitutional amendment. That means it's an ordinary law passed by simple majority. In the same fashion, if you have to change the salaries of president, vice president, ministers, you just need an ordinary law. It is not a constitutional amendment. Sir, what about CAG? CAG, Lokpal, Lokayukta, Central Information Commission, State Information Commission, Niti Aayog, all these we will discuss in governance because that comes under transparency, accountability. Council of Ministers headed by Prime Minister resigned due to pass of no confidence motion. Still they continue as PM until new PM is appointed. Correct? Yes. Okay, that is it for today. See you tomorrow, 6 o'clock in the morning. Till then, have a great time. All the best. Bye-bye.